Okay, we're going to continue on the purchase agreement journey. We ended last time talking about previously executed purchase agreements. And so we're on to deed and marketable title. What these pieces are talking about is what kind of deed the sellers are going to give to your buyers. Okay. Now there's a couple different options here. There's a warranty deed, which is our normal deeds that we usually use. What the seller is doing is they're warranting to the buyer their chain of title. They're saying to the buyer, hey, Mr. Buyer, your title that I'm giving you, your property rights that I'm giving you are whole. And for my time that I've owned it, there will be no lien, no mechanics liens, no weird liens, no attorney's fees, no anything like that on the title. That's what they're saying when they're giving you a warranty deed. Now, each one of these are a little bit different. And so you need to know how the seller is holding title to fill this out correctly. And as a listing agent on the listing side, um, you need to, there we go. On the listing side, you also need to pay attention to these purchase agreements as they come in. If you are representing a trust and the trust is going to be giving a trustee's deed to the buyer, you need to make sure that this is checked instead of warranty deed. And we see this missed quite often because listing agents don't always think to check what kind of deed the buyer is asking for. On the flip side of that, the buyer can ask for whatever kind of deed that they want. So even if the property is in a trust can still give a warranty deed, which gives the buyer a little more protection with their ownership. Okay. But there's more costs involved. Takes a little bit more time. The trust is warranting a certain amount of the title. Okay. If you're unsure about any of these and whether it applies to your transaction, call your closing company. Our closers are so good at this and they can tell you exactly what needs to be done and when it needs to be done. I did not know that a warranty deed could be given by a trust until I called my closing company. And I was like, this is what my buyer's asking for. Is that even possible? And then sure, sure it was. Sure it was, my closer said, and then walks you through the answer. Mm. Um, so four main options: warranty deed, which gives buyer the most protection in the chain of title, personal representative's deed, and a trustee's deed give limited title to the buyer. So a personal representative's deeds is usually used in an estate situation where either the court has decided someone's in charge of the estate or someone has been deemed as the personal representative for someone who's still alive. And so they're the ones signing the documents, but they're not actually the ones conveying ownership. They're just signing the documents on behalf of the person who is conveying ownership, right? Or the entity that's conveying ownership.
Okay.
Trustee's deed is the same way. A trust itself is its own entity. A lot of people put their properties into trust, or into a trust. And so they will then give a trustee's deed on behalf of the trust to the new buyer. Um, if you are dealing with a seller who has their property in a trust, the closing company can only make the check out to the trust. So if they don't have a bank account open in the trust's name, even though they are trustees, they won't be able to deposit the check. So just a little aside, a little FYI, if you're talking to your sellers and they have their property in a trust, you need to make sure that they have an account open in their trust, in their trust's name, to be able to deposit their funds. Okay. And then a contract for deed. is the buyer's giving the seller money up front. The seller is giving the buyer most of the property rights, but essentially the seller is becoming the bank. And so they hold back that right to take the property back if they're not paid through that contract for deed.
Okay.
Okay. So when, if you remember back to your schooling classes, when they're talking about your bundle of rights, right? If you think of your rights being a whole bunch of sticks, like I can give you, Alicia, the right to cross my property whenever you want. That's a right that I'm taking away from my bundle of property rights and I'm giving to you. That's what this deed and marketable title section is talking about. What type of rights are being given to your buyer?
Okay.
Okay. So then there's always more options than just these deeds. And so I have never seen this other category used. Maybe somebody has, and they can absolutely chime in and tell me about it. But there are other deeds that you can fill in here if that's the case for your situation. Okay. But most of the time, it's going to be a warranty deed, a trustee's deed, or a personal representative's deed. I rarely see contract for deeds anymore either. I did 10 years ago, but not so much anymore.
Okay.
Okay. Then we go on to page 7. We talk about possession. Okay. We have two options for possession. Seller shall deliver possession of the property immediately after closing. This is the one that's checked almost always, or other. And they leave this other really broad because it could be that your buyer is asking to move in early. And so then you would click other and see buyer move-in agreement attached to this purchase agreement is what you would write in there. And then that buyer move-in agreement would determine what the possession date is.
Okay.
Okay. It could also be a seller rent back situation where the buyer is going to buy the property, but the seller is going to stay in the property after closing and pay the buyer rent. And so we have another form for that one. It's called a seller rent back, the seller rent agreement. And that's what you would write into those. I'm sure there are other options that happen there. And so this could be just a date. Say we're closing today, but the buyer's, not, how about 2026? I do the right year. The buyer's not, doesn't want to take possession. The seller still has stuff to get out of the house. And so they're fine with letting the seller just hang out there or move stuff out for a week. If it's a family situation, we'll see this possession date be very different.
Okay.
Most of the time, it's going to be immediately after closing. Once a buyer buys the home, they want to get into the home,
Right.
right? So most of the time, it'll be immediately.
Okay.
274 to 275 talk about all the debris. So by the possession date, the seller is agreeing to remove all debris and personal property that's not included in the sale by that possession date. And this is usually where we run into problems on the day of closing, is because the seller doesn't have time, didn't allocate their time correctly, didn't
Mhm.
get help in moving their stuff out. And so, as a listing agent, I always called my seller the week before closing. Hey, this is the date. Before they do the walkthrough, all of your stuff, including trash, needs to be out of there. Do you need help? Do we need to ask for an extension? Right? Are you good to go? And so this is the agreement that the seller is making to the buyer, saying, yep, all their stuff is going to be out by that possession date. And then we get into a lot of legalese coming in. So linked devices, 276 to 279 talks about linked devices. So because a lot of devices require a sign in now, like the Nest thermostats, right? They require you to have an app and an account and a sign in piece. And so this talks about those linked devices that the seller warrants that they will either disconnect or discontinue their service. And then later on, it talks about passing on those services and those connections to the buyer. Hi, Brandon. Hmm.
Hello.
Hi.
Hmm.
Hi, Alicia.
Hmm. And so that's all about the linked devices. So like internet, right? You sign up with a service for internet by the date of closing, by the possession date, that internet needs to be either transferred to the buyer, which is not usually the case, or turned off, and those pieces need to be given back or taken from the property, right? So your router, do they even have routers anymore? This is something my husband deals with. I don't even know. Um, right?
Yes, you have to have one.
Yes, you have to have a router. What's the other one that we used to have? A router and a
Modem?
modem. Maybe that's what
You
I'm
have,
thinking. Do they
you have to
still
Yeah.
have
have both.
both? You
Yeah.
do. Okay. All right. Good. See? That's not what I deal with.
A lot of
That's
times
not
it's
my
one or
job.
the other.
Right. That's what I thought too. Like sometimes it's just one or
That's
the other.
kind of confusing. Yep.
Okay. Okay, so that's what talks about the linked devices. Then it talks about prorations. Essentially, we talked about prorations when we talked about taxes, right? That we're going to split, seller's going to pay from the first of the year to the closing date, and buyer will pay from the closing date to the end of the year. And that's what this area talks about here is those prorations. What it says in particular is all interest, unit owners association dues, rents, charges for city water, city sewer, electricity, and natural gas shall be prorated, so split based on closing date between the parties. Buyer shall pay seller for remaining gallons of fuel oil or liquid petroleum gas on day of closing at the rate of the last fill by seller. So all those prorations that we talked about, that makes sense, right? City water, city sewer, electricity, like once the buyer takes possession, the rest of those bills are their problem, right? For the remaining gallons of fuel oil and propane. This has always been a fight with clients on who should pay for it and why should they pay it. Okay. In the purchase agreement, unless it's agreed to differently elsewhere, the buyer is required to pay the seller for whatever fuel oil or propane is in the tank at the day of closing. As the buyer's agent, this is why it's important for you to go to a walkthrough so that you can go check and see what percentage is in that tank. As the listing agent, it's your job to get the documentation from the seller to determine how much they paid per gallon at their last fill so they can be paid back appropriately. So the seller can be paid back appropriately. Now, we do see in offers where buyers change this, right? They ask for the seller to just give them whatever propane or fuel oil is left in the tank at the day of closing, like it's personal property, right? And so if the seller agrees to that, that's fine. But with the terms of the purchase agreement, if you don't handle it anywhere else, the buyer has to pay for that. Make sure you let your buyer know that it's usually a couple $100s. So they're already bringing a lot of money to the table. The problem usually comes when the buyer has exhausted all of their funds and now they also have to write a $300 check for propane, right? So as a buyer's agent, just make sure if there's fuel oil or propane involved in the sale that they're required to pay for that at closing to the seller directly. That doesn't even have to go through the title company. Okay. Okay. Oh, then wonderful title and examination. This one, we're going to read this one because it's fun. As quickly as reasonably possible after the final acceptance date. We haven't talked about final acceptance date yet, but we will. Seller shall deliver any abstract of title and a copy of any owner's title insurance policy for the property to the buyer or buyer's designated title service Any abstract of title or owner's title insurance policy provided shall be immediately returned to the seller upon cancellation of this purchase agreement. So the seller is going to give over their abstract or their owner's title insurance policy to the closing company as soon as possible after the final acceptance date. It is then the buyer's duty to obtain the title services deemed necessary or desirable by buyer or buyer's lender, including but not limited to title searches, title examinations, abstracting, a title insurance commitment, or an attorney's title opinion at buyer selection and cost, and provide a copy to the seller. So in a residential purchase agreement, it is on the buyer to choose the title company that they want to do all of these searches, make sure that there's clear title that can be given to them, and it's the buyer's cost, okay? On a vacant land purchase agreement, it's the seller's cost to do this. And we talk about this a whole bunch in one of the videos that we did about net sheets that we give to our sellers and our buyers, and how it's different depending on what purchase agreement you're using. So for a home, it is the buyer's cost to get that title work done. Okay. It's also what's in the closing costs, right? So if we're asking the seller to pay for closing costs, the seller is actually going to be paying for some of these fees here. Then it goes on to say about marketable title. It's talking about if there are any liens or encumbrances on the property and what happens if you get through this search, these title searches, and those liens or encumbrances jump up. It says, seller shall use seller's best efforts to provide marketable title by the date of closing. Seller agrees to pay all costs and fees necessary to convey marketable title, including obtaining and recording all required documents subject to the following. So what this is saying is that if something comes up in the title search where the seller can't give marketable title or clear title to a buyer, that the seller is going to use their best efforts and pay for fixing that problem. Sometimes the seller's title insurance will come into play at that point. Sometimes we as agents have to help out and run around and try to find heirs and estate owners and the old lawyer who did the title work before. This is what this says, but it is the seller's job to do that. Here's the piece that people forget. In 294 to 301, it talks about if seller has not provided marketable title by the date of closing. So the title insurance or the title search is done before closing, usually 2 or 3 weeks before closing. If anything comes up, seller has to fix it. But if the seller cannot fix it by the date of closing, the seller automatically has an additional 30 days after that closing date to make that title marketable, which means your buyer is, whether or not they sign a closing date extension, they are locked into this purchase agreement to give the seller that 30 days. Okay. However, the buyer can waive any title defects if they want to. And we've had that happen where the buyer says, yeah, I'll take care of it after closing. I'm not worried about it. I know the person who has the lien, so I'll take care of it. It's fine. That's okay. The lenders don't always agree with that, but the buyer can waive those if they want to. Okay. Then it says, in addition to the 30-day extension, buyer and seller may, by mutual agreement, which means it has to be in writing and on paper with signatures, further extend the closing date. Lacking such extension, either party may declare this purchase agreement canceled by written notice to the other party, in which case this purchase agreement is canceled. Buyer and seller shall immediately sign a cancellation, confirming said cancellation and directing all earnest money paid here to be refunded to the buyer. So a lot of words for a cancellation. Essentially what it's telling you is what happens after that 30 days if the seller cannot give marketable title in that 30-day period that they have that automatic extension. then either party can declare the purchase agreement canceled and the earnest money will be refunded to the buyer, period. Okay, so even though the buyer's gone through everything, their inspections have been removed, their financing contingency has been removed, this purchase agreement is contingent on nothing. Buyer still has one more way to get their earnest money back, and that's if a title search comes back with issues and the seller can't fix it within this time frame. Okay.
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 And
Mhm.
it's 30 days from when you initiate the title search and you find out there's like an issue?
Nope. So it's 30 days from the date of closing. So
Oh,
whatever date of closing that you put in here on page 1.
okay.
So like we put July 23rd. So they would have 30 days after July 23rd if the buyer and seller don't sign a closing date extension. Once the buyer and seller sign a closing date extension, that 30 days gets moved
Okay.
to 30 days after whatever you've put on the closing date extension, right?
And so then they could move into the place in those 30
They,
days if they wanted to?
yep, so they could if they wanted to.
Mhm.
You would do a buyer move-in agreement. You would do an addendum or a amendment to the purchase agreement, adding the buyer's move-in agreement because the seller would still be the owner of the property while they're fixing these title issues.
Oh,
And so the buyer would then have to work with the seller on whether or not they pay rent, whether they have a security deposit, what happens if the property doesn't close, the seller's not able to give clear title,
mhm.
and how long the buyer has to move out. So yeah, so they could move in if both parties agree
Mhm.
before that. Hmm.
Okay.
Yeah, good questions. Okay, any more questions on that one? Title and examination. Essentially, seller has to give any information that they have relating to the title of the property to the buyer's closing company. Buyer's closing company or title company has to do the search. Seller has to give marketable title to the buyer before closing. That's really, in a nutshell, what this is all about.
Okay.
Okay. So then 302 to 306 talks about subdivision of land, boundaries, and access. If the sale constitutes or requires a subdivision of land, which means you have like a 40-acre chunk and you're splitting off a part of it, okay? Seller shall pay all subdivision expenses and obtain all necessary governmental approvals. Seller warrants that the legal description of the real property to be conveyed has been or shall be approved for recording as the date of closing. Seller warrants that the buildings are or shall be constructed entirely within the boundary lines of the property. Seller warrants that there is a right of access to the property from a public right of way. So if the seller is splitting up a property to be able to sell it, and we see this in town with, if somebody has a double lot and they want to sell part of the lot, but they're keeping the house, this is what comes into play. Essentially, it's saying the seller will pay for that subdivision piece. It also warrants that everything is within the boundary of the property and that the property has a public right of way of some kind. It's not landlocked, right? There is a way to access the property. If these things are not true and the seller knows those aren't true, they have to disclose it. Okay, which is what the seller's property disclosures are for. They know a corner of their garage is over on the neighbor's property, they got to disclose it. Okay. Then it talks about mechanics liens. Mechanics liens are can be put on the property as regular liens, as mortgage liens, as attorney liens, as court liens. They are essentially, you file something with the county and you say, hey, I did work on this property. Here's my proof I did this work. And so if this seller ever sells the property, they're required to pay me because they haven't paid me yet. Okay. Mechanics liens in particular are work that has been done within 120 days of closing. Okay, so it's about 4 months. So if there's any work that's been done on the property by a vendor of some kind, you need to have a mechanic's lien waiver, which says that the mechanic, right, the vendor, has been paid in full for whatever they did. And the reason that they do this is that if you have work done, particularly when we have home inspections, we end up asking the seller to have a professional come in and fix something, fix the electrical system, right? And so we need proof as the buyer and the buyer's agent, we need proof that that work has been paid for and that that vendor isn't going to put a lien on the property that my buyer now owes because that's not my buyer's bill, right?
Right.
So that's what these mechanics liens are all about. Now, most of the time, you don't have to worry about it. The title company takes care of all of these mechanics liens. The seller will let the title company know who the vendors are. The title company is usually the one that reaches out. There are times where the title company has issues reaching out to a vendor to get a mechanics lien because they're more of a spit and a handshake business, right? And so you might have to get involved at that point to go get that mechanics lien, sorry, mechanic lien waiver from that person to prove that they've been paid.
Okay.
Okay. Okay, then we talk about notices, wonderful notices. We talked about this a little bit last time too when we were talking about property taxes. And that piece was talking about notices about assessments being assessed on the property. This notice is talking about any notice from any governmental authority as to condemnation proceedings, violation of any law, ordinance, or regulation. Okay. It also goes on to talk about if the property is subject to restrictive covenants, seller warrants that seller has not received any notice from any person or authority as to breach of the covenants. Any such notices received by the seller shall be provided to the buyer immediately. Discriminatory restrictive covenants, blah, 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 are illegal and unenforceable. An owner of real property may permanently remove such restrictive covenants from the title, blah, blah, blah. So there are two pieces to this. One, and I feel like this should be a no-brainer, but apparently we have to have it in writing. If the seller receives any notice from any authority whatsoever about their property that they're selling, that information needs to get to the buyer immediately. Period. No stop, no cap, whatever the kids say, right? Then it goes on to talk about discriminatory restrictive covenants. So in the past, there were restrictive covenants that were put on properties that said that a family of color not own property. Okay. They were terrible. They were wrong. And what the state and the federal government went through, and instead of fixing everybody's title throughout the whole country where these restrictive covenants put into place, they just deemed them illegal and unenforceable, period. So if you ever come across restrictive covenants with those terms in it, just know that those are illegal and unenforceable. And this just puts it in writing between the buyer and seller so that everybody's on notice.
Okay.
We up here don't really see those type of restrictive covenants in northern Minnesota. Sometimes in the cities you do. In older, like old parts of the smaller cities up here in Bemidji, in I know St. Cloud. I don't know about Alexandria and Sauk Center. You might see those type of restrictive covenants. Just know they're illegal and unenforceable. You can sell your property to whoever you wish. Okay.
Okay.
Then it goes on to dimensions. It talks about buyer acknowledges that any dimension, square footage, acreage, or improvements are approximate. All of the numbers that we give are approximate. If buyer wants a specifically accurate number for square footage of the property, it's up to them to go get that at their cost and their expense. Now, with that being said, that those things are acreage is approximate. It might be a quarter of an acre less, right? It might be a quarter of an acre more. Square footage is approximate. It might be 3,000 feet. It might be 3,001 feet. They're approximate. We still, as agents, should get these numbers as specific as we possibly can. We are not surveyors, right? So acreage is a little harder. Square footage in particular, we should be getting those dimensions and their square footage as close as we possibly can. So while the numbers are approximate, which is what you need to let your buyer know, we do try to be as accurate as possible. That's all that says. Access agreement. Seller agrees to allow reasonable access to the property for performance of any surveys or inspections agreed to in this purchase agreement. So essentially what this says is if the buyer has asked for any kind of work to be done on the property before closing, that the seller agrees to allow access to the property. They can't stop an inspector from going into the property if they've agreed in this purchase agreement that they will allow the buyer to have an inspection. Okay. Again, something you don't think that should have to be in writing. Apparently there was a lawsuit somewhere and now it has to be in writing. On the flip side of that, if your buyer does not ask for an inspection in the purchase agreement, then the seller can refuse to allow that inspector into their property. You would have to amend your original agreement to be able to add that inspection. Okay?
Okay.
Okay. More legalese. And I'm gonna run through probably risk of loss to predatory offenders. I know we're at time, but I'm gonna run through that. So if you need to jump off, Felicia, you're more than welcome to. Because I'll post this anyway. It'll be recorded and posted.
Okay.
Okay. Okay. Risk of loss. This one's one of my favorites. If there is any loss or damage to the property between the date of this purchase agreement and the date of closing for any reason, including fire, vandalism, flood, earthquake, act of God, risk of loss shall be on the seller. So essentially, if the property is damaged by any of those things, the seller is the one who has to bring the property back into substantially the same condition as when you wrote the offer. Okay. It goes on to say if the property is destroyed or substantially damaged before the closing date, this purchase agreement is canceled at buyer's option by written notice to the seller or licensee assisting the seller. If the buyer cancels this purchase agreement, they'll immediately sign a cancellation and earnest money will be refunded to the buyer. So if a tornado comes through and it completely destroys the property, it is up to the buyer whether or not they want to cancel the purchase agreement. Most of the time, the buyer's like, yeah, I don't want to buy it anymore, right? The value isn't there. The house is now destroyed. There's no reason to. There are some times where the property is destroyed, usually by a fire in our industry, and the buyer and seller then renegotiate a purchase price, and the buyer buys the property anyway. That does happen. But per this, it's in the buyer's court. If something like this happens, fire, vandalism, flood, earthquake, act of God, if something like this happens, it's up to the buyer whether or not they want to continue with the purchase. Okay. Time is of the essence. I love this one. It says time is of the essence in this purchase agreement. You get to determine what essence means. We know what time means. What this means in most state statutes is that as soon as reasonably possible, the things in here will be done, right? Time is of the essence, meaning we have deadlines within this purchase agreement that we have to follow. So timing is important. Okay. Calculation of days. Any calculation of days begins on the first day following the occurrence of the event specified and includes subsequent days, ending at 11:59 on the last day. This is important when we calculate the home inspection days, right? The final inspection, the final acceptance date is day 0. So if we put a 10-day home inspection contingency in there. The final acceptance date is day 0. And the next full day is day number 1. That's what starts your count. This confuses people quite often, just so you know. Any calculation of days begins on the first day following the occurrence of the event specified. So if we go back up to the home inspection portion, okay, within blank calendar days of final acceptance date. So if the final acceptance date is today, is the 2nd, then day 1 of that 10-day period is tomorrow, is on the 3rd. Okay. Then it ends at 11:59 on the last day. On that 10th day, it'll end at 11:59. What this means is that if you don't have negotiations done within the home inspection period, within that 10-day period, that you have until 11:59 of that 10th day to furnish a cancellation to the seller. Or the seller has 11:59 on the 10th day to give you an agreement, an agreed negotiated amount based on the home inspection results. Okay. There are agents that do change this timing to something different, like 9 p.m., which seems more reasonable in my opinion. I don't want to be staying up until 11:59 to see whether or not the buyers are going to give me a cancellation on my listing. Okay. However, I never changed any of these timings, any of these numbers, because I just made sure my sellers were ready to go by 8 o'clock the night of the 10th day. Same thing with my buyers. If we weren't getting conversations with the sellers about negotiations and our contingency was going to be up, I had a cancellation signed by my buyers ready to go in case I needed to hit this deadline of 11:59. Okay. Then it talks about business days and calendar days. Business days are days which are not Saturdays, Sundays, or state or federal holidays. That's all. That's what business days are. Calendar days are everything, including Saturdays, Sundays, and state and federal holidays. Okay. This is the piece that's important. For purposes of this agreement, any reference to days means calendar days, unless there is some kind of statute somewhere else that says it means something different. So if you only see days within this purchase agreement as you're reading it, you can assume that they mean calendar days. Okay. Release of earnest money. Buyer and seller agree that the earnest money holder, which is usually the listing agent, shall release the earnest money from the earnest money holder's trust account at or upon successful closing of the property, pursuant to a written agreement between the parties, which may be reflected in the cancellation, upon receipt of an affidavit of cancellation under Minnesota statute, or upon receipt of a court order. What this is saying in release of earnest money is that even though in the purchase agreement, everything says both parties will sign a cancellation and earnest money will go to the seller, or both parties will sign a cancellation and the earnest money will go to the buyer, we cannot, as a brokerage, release earnest money unless we have a successful closing, something in writing that is signed by both parties agreeing where that earnest money goes, an affidavit based on the state statute, or a court order. Just because the purchase agreement says that both parties agree to cancel and give the earnest money to whoever does not mean that we can give that earnest money out. We have to have signatures from everybody. And if we can't get signatures, then we need a court order. Okay. You will run into this more often than you would think, particularly about earnest money. Okay. Default. So this talks about if the buyer defaults on any of the agreements in the purchase agreement. Essentially, when the buyer puts in a purchase agreement, they're saying, hey, I want to buy your property. And as long as these couple things are right, I'm going to buy your property. Okay. This says if the buyer defaults on any of the agreements here, including not getting the earnest money in time, the seller may cancel this purchase agreement, and any payments made here, including earnest money, shall be retained by the seller as liquidated damages, and buyer and seller shall affirm the same by a written cancellation agreement. Okay? This goes back to that can't give out earnest money unless we have one of those. They got to sign something. But if the buyer defaults, if the buyer doesn't do something, if the buyer doesn't get their information to the lender in a timely manner, the seller can cancel the purchase agreement. If the buyer or the buyer's agent doesn't get the earnest money in on time, the seller can cancel the purchase agreement. Okay, that's talking about buyer defaults. Then it goes on to say if buyer defaults in any of the agreements here, seller may terminate this purchase agreement under the provisions of either Minnesota statute, whichever is applicable. If either buyer or seller defaults in any of the agreements here, or there exists an unfulfilled condition after the date specified for fulfillment, either party may cancel this purchase agreement under Minnesota statute. Whenever it is provided here that this purchase agreement is canceled, said language shall be deemed a provision authorizing a declaratory cancellation under Minnesota statute. So essentially, if the parties do not follow what they've agreed to in this legal agreement, then somebody can cancel. Somebody can say, hey, you didn't do what you're supposed to do, so we get to cancel now. Again, we can't release the earnest money until we have a cancellation signed by all parties or a court order or an affidavit. But this is saying, yeah, if somebody's not doing something, then yeah, you can get to cancel. It goes on to say, if this purchase agreement is not canceled as provided here, where they sign the cancellation, buyer or seller may seek actual damages for breach of this purchase agreement or specific performance of this purchase agreement. And as to specific performance, such action must be commenced within 6 months after such right of action arises. Now, I will tell you, I am not a lawyer. I have not dealt with specific performance before, but it does get thrown around quite often in conversation between agents, especially when a purchase agreement is falling apart. Okay. What this says is if someone does not do what they're supposed to within this legal contract, and then they refuse to sign a cancellation, that either the buyer or the seller can seek actual damages. They can go to court. They can either seek actual monetary damages or specific performance, meaning they're asking the court to tell whoever, whichever party, that they have to perform on the agreement that they made. This comes into place specifically when you have a buyer who's putting in a non-contingent purchase agreement. They have cash, or they're not making it contingent on financing. They're not having an inspection, right? They're just telling the seller, I'll buy your property. All done. As long as there's marketable title, I'll buy your property. We're good. And the buyer decides not to then go through with that agreement. The seller has every right to take them to court and sue them for specific performance and get actual damages for the breach. So when you are writing an offer for your buyer, please be very clear with them that if they are unsure or think they can get out of this agreement in some way, that legally, well, yes, the seller can be very nice and sign a cancellation and just never sell to that buyer ever again. Legally, the seller can take them to court and either force them to follow through or get actual damages, monetary damages. Okay. Then this is where we will end for today. This is the notice regarding predatory offender information. We as real estate agents, and this is an agency too, guys, so I'm sure you know, we as real estate agents are not required to tell anybody about predatory offenders in the area. Our clients have to go to this wonderful website right here and look up any predatory offenders in the area. It is not on us or the sellers who disclose about predatory offenders. Okay. I think that's all I got for you guys today. We have one more time of this purchase agreement, I think, and then we will be done. Purchase agreement is a big document. There's a lot of pieces. Buying a home is more complicated than it used to be. When you just had a one-page purchase agreement, right? I don't know that anybody remembers that in our offices. Maybe a couple of us remember the one-page purchase agreement. But there is a lot to get through. There's a lot of pieces to know. You know all of this from your classes that you've taken. You just might have forgotten. Okay. If you have any questions, let us know. Otherwise, have a wonderful 4th of July, and I will see everybody next week.